Attention everyone planning to move to the US. Starting in 2026, green card rules are changing dramatically. Whether you're applying for work, family sponsorship, or even through investment, these new rules could delay your application or even block you entirely if you're unprepared. In this video, we break down exactly what's changing and how you can stay ahead before it's too late. The first thing to understand is that these changes are part of a broader effort by the US government to modernize immigration processes, streamline applications, and address backlogs that have accumulated over the last few years. Waiting times for family-based green cards, employment-based visas, and other categories have grown substantially, leaving many applicants frustrated and unsure about their future. By introducing new rules in 2026, the government aims to improve efficiency while also ensuring compliance and national security. One of the most significant changes involves the eligibility criteria for employment-based green cards. Starting in 2026, applicants will face stricter verification requirements regarding their employment history, qualifications, and the financial stability of their sponsoring employers. For example, companies sponsoring foreign workers will need to provide detailed proof that the position cannot be filled by a US citizen or permanent resident. This is designed to prevent abuse of the system but also means that applicants may need more documentation than ever before. If you're planning to apply under an employment-based category, this could lengthen the preparation phase. You'll need to gather pay stubs, tax records, detailed job descriptions, and evidence of recruitment efforts. While this may seem cumbersome, being prepared ahead of time will make your application smoother and reduce the risk of delays or denial. Employers also need to be proactive, as incomplete sponsorship packets could affect your eligibility. Family-based applicants are also affected. One major change in 2026 is a redefinition of priority categories for spouses, children, and other close relatives of US citizens and permanent residents. Previously, some categories were oversubscribed, leading to multi-year waits. The new rules aim to adjust quotas based on demand and streamline processing for immediate relatives. This doesn't mean everyone will get faster approvals, but it does mean the system will prioritize close family connections over distant relatives, which could shorten wait times for some applicants. For anyone planning to sponsor a family member, this is critical information. The updated rules will require sponsors to provide more detailed proof of relationship, financial capability, and domicile in the United States. In other words, the government wants to ensure that sponsored family members are genuinely connected and that sponsors can support them without relying on public benefits. Another significant change concerns the public charge rule. Starting in 2026, applicants may face stricter scrutiny regarding their financial self-sufficiency. The government will evaluate income, savings, employment history, and health coverage more rigorously to ensure that new immigrants are not likely to become dependent on public benefits. This is particularly important for families, students, and lower-income applicants. Applicants will need to demonstrate that they have enough resources to support themselves and their dependents, at least in the initial years after arrival. Health insurance coverage is also coming into play. While US green card applicants have always needed to meet certain health requirements, the 2026 rules will make proof of adequate health coverage a more prominent part of the process. This could include private insurance, employer-provided coverage, or government-recognized programs. For those without existing coverage, this may mean arranging a plan ahead of submission, which could add to the preparation timeline but also helps ensure that new permanent residents have access to health care from day one. The application process itself is also undergoing changes. One of the biggest updates is the introduction of more digital processing options. By 2026, USCIS plans to transition many green card forms and supporting documents to an online-first system. This is intended to speed up processing and reduce paper-based delays. However, it also means that applicants must be comfortable navigating digital platforms, scanning documents, and meeting strict technical specifications for submission. Those unfamiliar with digital filing may want to get assistance from legal advisors or immigration consultants. Security and background checks are another area of focus. The 2026 rules will expand the scope and depth of security vetting for green card applicants. Fingerprinting, interviews, and background checks will be more detailed, particularly for applicants from countries that have higher levels of immigration scrutiny. While these checks are designed to enhance national security, they may also extend the timeline for approval. Applicants should be prepared for additional interviews or requests for documentation. For current green card holders, the changes also matter. Those applying for renewal or citizenship may see updated requirements for continuous residence, physical presence, and proof of financial stability. The government is emphasizing that maintaining permanent resident status requires ongoing compliance with these rules, so it's essential to keep records of employment, taxes, travel, and other critical documents. Ignoring these requirements could complicate renewals or future naturalization applications. One area that's particularly important for investors and entrepreneurs is the EB-5 Immigrant Investor Program. Starting in 2026, the program will undergo adjustments regarding investment amounts, targeted employment areas, and project eligibility. Applicants hoping to qualify for a green card through investment should be aware that the minimum investment could increase, and proof of job creation will be more rigorously enforced. This is a major shift for anyone planning to use this route and may require revisiting investment plans and documentation well in advance. Students and recent graduates are also impacted. Optional practical training, OPT, and other student-related employment pathways will see stricter rules about transitioning to green card status. Employers sponsoring recent graduates may face additional paperwork requirements, and students will need to ensure that they maintain valid status throughout the process. Failing to do so could disrupt eligibility for permanent residence, so careful planning and consultation with university immigration offices or legal advisors is highly recommended. Visa backlog and priority dates remain a critical factor. The 2026 rules attempt to address long-standing delays, but applicants should still be aware of category-specific wait times. For countries with high demand, such as India, China, Mexico, and the Philippines, the new rules may help somewhat, but applicants may still face multi-year waits. Monitoring the visa bulletin, understanding priority dates, and being prepared for long timelines remain essential strategies for anyone applying in these categories. It's also important to note that the 2026 rules are part of a broader policy shift. The government is increasingly focusing on ensuring that immigration benefits align with economic needs, family unity, and national security priorities. This means that applicants who can demonstrate strong ties to the U.S. economy, family, or community may have an advantage. Documentation, planning, and legal compliance are more important than ever. Legal advisors and immigration experts are urging applicants to prepare early. Waiting until 2026 to submit documents may result in delays due to increased demand and stricter requirements. Early preparation includes collecting employment letters, financial statements, proof of relationships, and health coverage documentation. For investors and entrepreneurs, project plans and employment projections need to be finalized well in advance. Being proactive now could save months of processing time later. Another key consideration is travel. Applicants planning to leave the U.S. while waiting for green card approval must be aware of travel restrictions and potential impacts on their application. Advanced parole, visa stamping, or travel permits may be necessary to avoid jeopardizing eligibility. Understanding the interplay between travel and green card processing is essential for avoiding unintended complications. For families, these changes are particularly significant. Children, spouses, and elderly dependents must meet the updated requirements alongside the primary applicant. This includes financial self-sufficiency, health coverage, and documentation of relationships. Sponsors must be prepared to provide detailed evidence for each dependent, which adds complexity but ensures smoother processing if done correctly. The bottom line is clear: 2026 is bringing major changes to U.S. green card rules, and anyone planning to apply or sponsor someone should be prepared. Employment-based, family-based, student, investor, and renewal applicants are all affected. Preparation, documentation, financial planning, and compliance with health and security requirements are more important than ever.